Good evening. What a wonderful group. What a wonderful welcoming group here. It was quite a sight to come into this building tonight with Dr. Ramirez and have him accosted by a lot of students who wanted not only his picture but his autograph. And he feels like a rock star now, I think. So that's a good thing. And since I'm getting my picture taken up in front of people too, maybe I'm kind of like part rock star, I don't know. I'm Brian Niehoff. I'm the Associate Provost for Institutional Effectiveness here at K-State, and I'm representing the Provost Office. The Provost sends her regrets. She has been in meetings at the Board of Regents all day long, and so was not able to make the event tonight. But I am here to just offer my welcome to everybody here, as well as our speaker for the evening, as well as our judges who've been around all day long. We really appreciate this. It's been a wonderful day, Constitution Day, in addition to the Dorothy Thompson lecture, which is where we're talking about tonight. The Provost Office established this civil rights lecture in 1994 in recognition of Dorothy L. Thompson and her contributions to the field of human rights on campuses throughout Kansas and the nation. Ms. Thompson was the director of the Office of Affirmative Action from 1972 to 1985 when she became the Associate University Attorney. Ms. Thompson served in that office until her untimely death in 1992. Dorothy was a role model for women and attorneys in Kansas. She was highly regarded by persons of all political leanings for her diplomacy, her judiciousness, and her effectiveness in her role. Dorothy Thompson had an abiding respect for all people and a profound commitment to fairness and equity. A civil rights lecture series is a particularly fitting memorial for her, and we really appreciate this lecture series. The selection of speakers in the organization of the Dorothy L. Thompson Civil Rights Lecture Series is done by an organizing committee that works to bring these programs to campus. And we're fortunate to have these people here. Would the committee members please stand up if you're here? Let's give them a hand. Thank you all. As usual, you've done a wonderful job. Those of you who are standing up there are some seats, so feel free to come to any table here. There's some seats up front. Don't be afraid of this. Isn't like church. But there's seats up front. There's seats over here. So feel free to find some seats. We also are very fortunate to have a group of loyal and dedicated patrons who support this series. Are any of the patrons here tonight for the lecture series? Let's give them a round of applause anyway, because I think they deserve it. It's always important. And then finally, we're very honored to have our appellate court panel of judges who have been here all day long, and this afternoon had a docket day over in the Forum Hall. Would the judges please stand and be recognized as well? And the chair of the committee is Dr. Joe Sutcliffe Sanders, who is in class right now and won't be able to be here tonight. So in absentia, let's give him a round of applause too. So, all that being said, tonight's lecture is entitled Affirmative Action at the Crossroads, the Uncertain Future of Race-Conscious College Admissions. And this is an extremely timely topic as we think about all the things that are going on in universities these days. Our speaker is Loyola University of Chicago law professor Stephen A. Ramirez. Prior to his appointment at Loyola University, Professor Ramirez taught at Washburn University School of Law in Topeka, where he was the founding director of the Business and Transactional Law Center. Before joining the Washburn Law faculty, he was a partner with Robinson Curley Clayton, a Chicago litigation firm specializing in corporate securities and banking litigation. He also served as a senior attorney for the Resolution Trust Corporation and as an enforcement attorney with the Securities and Exchange Commission. Professor Ramirez teaches business organizations, a Securities Litigation Seminar, and other business-related classes within the law school. He's published extensively in the areas of corporate governance and financial regulation, including the impact of the Sarbanes-Oxley Act of 2002, and most recently he's published a book, Lawless Capitalism, the Subprime Crisis, and the Case for an Economic Rule of Law. Professor Ramirez graduated from the University of Missouri in 1983 and graduated cum laude from the St. Louis University School of Law in 1986. So we're very proud to have Dr. Ramirez here tonight. As as these lectures, if you've never been to one of these lectures before, this isn't just a lecture, a one-way sort of a thing. There's going to be some involvement of the audience. And to explain how this whole evening is going to go, I'm going to first introduce one of the committee members, Professor Michael Kay, to tell you about the program, and then he will MC the rest of the evening. So, Dr. Kay.
Well, good evening, and I'd also like to thank all of you for coming. This is a very diverse group, just the kind of group who should hear the talk that we're going to have tonight and participate. And I'd also like to thank the judges, Judge Standridge, Judge Green, Justice Larson of the State Supreme Court, who've come here to spend time with us and join us in this particular evening. And it's just a pleasure to have them here and to celebrate Constitution Day with them. Moreover, we also have someone else to thank, and that is our Vice Provost for Diversity, Dr. Myra Gordon, who is here. She is a longtime supporter of our program, of our Civil Liberties Lecture Series, and she is certainly the strongest, clearest voice for racial and ethnic diversity at this great university. So welcome, Dr. Gordon. And she's here. I'll be very brief about what our program is going to be. It will begin, of course, with a lecture by Dr. Ramirez, and what he will be talking about will be a case presently before the United States Supreme Court, which will be decided this year. The outcome of this case could have an important effect on the admissions of African American and other and ethnic groups, Latinos, to our universities. Whether that happens or not, we're not sure, but there have been over 87 briefs filed by friends of the court. In other words, the country is watching this case very closely, and he'll explain it to us. After that happens, we will pause, we'll have some refreshments, and then you are all seated at tables. You'll get a chance to stretch your legs, and we're going to ask you to remain. And what we're going to do for about 20 minutes is we're going to participate in this discussion by talking together about the issue, should colleges and universities use race-conscious admissions policies? In other words, should they consider a person's race or ethnicity in deciding whether to admit them to college? What's good about that, or what's wrong with it? And I think you all have lots of things to say, especially our friends from Ecuador who are here seeing a world that may be very new to them, and hearing about traditions that they may not have been familiar with before coming here to Kansas. This discussion will be guided by a number of us, members of our committee, Professor Ramirez, another visitor here, and I should say a great product of K-State, Nick Kenny, who graduated from K-State, goes to Washburn Law School now. He was a student of Dr. Maynard here, and he'll be one of the people guiding the groups. And we'll be talking about how you feel and what you think about this question. And when that's over, we're going to have each table take a vote on how the members feel about this issue. It'll be a yes or no vote. That will not, shall we say, that won't express the richness of our discussion, but it will give people a feeling of how does this group feel about this major issue in American law and politics and society. And so the next person you'll hear from after Professor Ramirez speaks is Socorro Herrera, Dr. Herrera, and she'll explain how the tables will be organized. So there's a lot coming. It's a three-part program. It's a great group, and I look forward to hearing your discussions and talking with you. Thank you.
Good evening. First, I want to say how fortunate I am to be here tonight. This is a wonderful campus. It's beautiful outside. I've been to K-State quite a bit over a long period of time, and I'm always struck by how beautiful this campus is. You might have noted that I graduated from University of Missouri. Your campus is more beautiful when I come here and Missouri wins than when I come here and Missouri loses. And unfortunately, I've spent too much time here in the wake of a Missouri defeat, especially in the football stadium. But I love K-State. I've always liked K-State. I think very highly of it, and I feel really lucky to be here tonight. I want to thank the members of the committee for selecting me for this exercise, and I look forward to talking about this. So, okay, affirmative action in Fisher. Well, Fisher versus Texas is a United States Supreme Court case that will be heard orally. There'll be an oral argument on it October 12th, and then sometime in the spring, there'll be a decision. And what's at stake is a very important issue. To me, there's no more important issue than the idea of how we can get the most out of our people in this great nation. That we all should be concerned with making sure that we get the most innovation, the most ideas, the most talent possible out of our population. Only then can we compete to a maximum extent of effectiveness in a globalized marketplace and as a global power. So to me, the stakes are that big. It's whether or not we can get the most talent possible out of our people, and I think that's at stake in the Fisher case. Let's just start with the legal framework foundation here. It starts with the 14th Amendment, which was put in place after the Civil War in 1868. And this is the exact text of the 14th Amendment Equal Protection Clause that's at issue. No state shall deny to any person within its jurisdiction the equal protection of the laws. Now, context is very important in understanding what this amendment is about. It was after the Civil War. The newly freed slaves were subject to black codes throughout the South. They couldn't enter into contracts that would be enforced by courts. They didn't have property rights on par with white members of the South. And so Congress responded to that with this amendment to the Constitution that was specifically focused on protecting the disempowered in the South, the newly freed slaves. And there was never any concern here about protecting those who had power under the pre-existing status quo. This was not an amendment that was designed at its incipiency for making sure that those with economic resources and political power remained in the same position that they were in before the Civil War. It was all about helping former slaves. So in one of the earliest interpretations of the 14th Amendment Equal Protection Clause, Strouder versus West Virginia, the court openly stated what the purpose of the 14th Amendment Equal Protection Clause was. And the purpose was to assure that the colored race enjoyed all the rights of all other U.S. citizens, and that those people, the newly freed slaves, were given the protection of the government and the law just like any other citizen of the United States. It's noteworthy here because there are those who believe that the Constitution should be interpreted strictly in accordance with the intent of the framers of the Constitution. There's a school of thought that that should be the first and foremost thing that we do when we interpret constitutional provisions. And so here we are in 1880. It's only 12 years after the Equal Protection Clause was drafted and the 14th Amendment was enacted into law. And the people who were closest to what was going on at that time period, the Supreme Court of the United States, was certainly cognizant of the negotiation of the 14th Amendment. Said very openly in a Supreme Court opinion that it was about protecting the newly freed slaves. I don't think you could get language much clearer than that. Okay, what's the history of affirmative action insofar as the 14th Amendment is concerned? Well, for 35 years, the idea that you could have race be a plus factor in admissions has enjoyed the support of at least 5 votes on the Supreme Court of the United States. So in 1978, the holding of the Bakke case, Bakke versus Board of Regents of California, and involved the medical school at University of California, Davis, held that the injunction that was issued against the University of California saying that they could not consider race had to be set aside. And there were 5 votes in favor of that. The key vote here was the vote of Justice Powell. And Justice Powell's vote was all about the benefits of diversity. And he articulated those benefits in a very clear and effective manner. Those benefits are that in an educational setting, it helps to have as many perspectives as possible coming together to discuss any given issue. The more perspectives you get, the better resolution you'll have, the more robust the discussion will be about that issue, and you end up with superior pedagogical outcomes. People learn better when they are the beneficiaries of a more robust discussion that includes as many possible perspectives as possible. So he articulated a compelling state interest that the University of California had in making sure that their campus benefited from this robust exchange of ideas in terms of diversity. And he said that that compelling state interest justified the University of California to think about race and consider race as a plus factor in determining whether a given student, a given applicant, should be admitted to the University of California Davis Medical School. He attached to his opinion the Harvard plan, because Harvard had been embracing diversity on all dimensions, not just racial diversity or ethnic diversity, but geographic diversity, diversity in terms of talents and experiences, but diversity writ big for many, many years. And so he actually took the Harvard plan and made it part of his opinion. And that was the beginning of Supreme Court sanctioned affirmative action in college admissions. In 2003, the court again took up this same issue in the Grutter case involving the University of Michigan. And the court stated, Justice O'Connor, writing for the majority, the court stated, we endorse Justice Powell's view of student body diversity. We find that it's a compelling state interest. In Grutter, Michigan Law School engaged in a highly individualized, holistic review of each applicant's file. That's very important, because what we're trying to do here is unlock the benefits of diversity without necessarily engaging in racial discrimination. And it's a balance. How much do you want to spend thinking about diversity in terms of transaction costs? What are the benefits you get? And try to minimize the impact of the racial classification. And so as a result, Justice O'Connor was very impressed by the fact that the Michigan Law School used this holistic review where they looked at an entire applicant beyond just race, beyond just GPA and LSAT score, law school admissions test, and individualized their consideration. So under those conditions, Justice O'Connor concluded that, in summary, the Equal Protection Clause does not prohibit the law school's narrowly tailored use of race in admissions decisions to further a compelling interest in obtaining the educational benefits that flow from a diverse student body. I apologize for the text-intensive nature of these slides, but I think it's really important. The lawyer in me understands that it's really important that we look at the text of the governing law. I can't put the whole Supreme Court opinion before you on these slides, so what I did is I tried to get the key language. Most of the slides consist of key language from Supreme Court opinions or other governing legal authorities. I think that this is the best summary of the holding of Grutter, but I think it's good also to consider the underlying rationalization of Justice O'Connor's outcome in that case. And basically, there were a few things that I think she focused on that are key elements of a sound, well-designed diversity program. And one is that you're not looking at any kind of quotas. Quotas have always been unconstitutional. When you hear people talking about someone favoring quotas in admissions, that's been a dead issue for many decades now. No school uses quotas. Federal courts will strike quotas down, and that's been the case since even before Bakke, but certainly since Bakke in 1978. So we don't use quotas. Instead, the idea of getting a robust exchange of ideas in the classroom, of breaking down racial stereotypes and enhancing cross-racial understanding is a function of having a critical mass in the classroom of people with outsider perspectives. So whatever issue it is, you're trying to bring in new perspectives and then empower those perspectives through enhancing the environment, the learning environment in the classroom, by making sure there's enough diversity in the classroom that people can speak their minds freely. That's an important point. You want people to be able to speak their minds freely. So there is no definition of critical mass. And it certainly should not turn upon the demographic realities of any given state. Instead, critical mass is about making sure you get maximum benefit from diversity in the classroom. She also talked about the need for diversity throughout American society, because I think this feeds in to her analysis on whether or not diversity is a compelling state interest. And a group of high-ranking military officials, generals, admirals, etc., had filed a brief in the Grutter case, and they did so again recently with respect to the Fisher case that we're going to get to in just a moment. And the point here is that the military finds that you have to have a racially diverse officer corps in order to make sure that the military can function at its highest and best level. You can't have an officer corps of all white Americans, and soldiers who are all Latino and African American. Communication, cultural understanding, cultural empathy, the ability to lead in a legitimate way, in a way that is recognized as legitimate. This all turns upon things like having diversity among your officers as well as among your soldiers. So the military is quite interested in pursuing diversity, and in fact, I think the military on some levels is ahead of the rest of American society in how they pursue diversity, which is why, for example, generals like Colin Powell were able to advance at a relatively early time after the civil rights movement to the highest levels of the military. So the military wants diversity, and that's something that was very persuasive to Justice O'Connor. Similarly, American business has made clear for years that they need the broadest array of skills possible, including the broadest array of experiences and perspectives, right? It's cognition. It's about whether or not people bring to the table a variety of experiences and perspectives that can help business compete better in a globalized economy. So American business, both in the Grutter case and in the case pending before the Supreme Court today, the Fisher case, has been loud and clear that we need to harness the absolute maximum extent of the talents of the full American population. We can't afford to leave anyone behind, and we need to have diverse perspectives to make sure that our businesses can compete to the maximum extent possible. So these are quotes from Justice O'Connor's opinion that underline her thinking about why it is that diversity is a compelling state interest, backed by amicus briefs submitted by friends of the court who aren't actually parties in the litigation, articulating their interest in the outcome of the litigation. So the military and big business both went on record in a strong way supporting the use of diversity as a compelling state interest. So then Justice O'Connor began to make some comments about what a well-designed diversity policy should look like. And she made the point that race-conscious admissions policies ought to be limited in time. They ought not to be open-ended. And so many schools have crafted race-conscious admissions policies with a view towards periodic reviews to see if they're still needed to achieve the compelling state interest of diversity in the classroom. So you don't want a permanent plan for never-ending embrace of diversity with race consciousness as part of your diversity plan to adhere to the Grutter approach. She also stated that it's been 25 years since Justice Powell first approved the use of race to further an interest in student body diversity in the context of public higher education. Since that time, the numbers for minorities have gone up. And so she anticipated that 25 years from 2003 or 2028, the use of racial preferences may no longer be necessary. So this is the idea that as America becomes more diverse, as we become more comfortable with our diverse human resources, as we bring along the talents of more and more of our underrepresented minority communities, then this compelling state interest in using race to unlock the benefits of educational diversity may expire, it may run out. We may not need it forever, it's a temporary idea. So, okay, that brings us to Fisher versus Texas. And this is a quote from the lower court of the Fisher versus Texas litigation and also some of the Fifth Circuit's thinking on what was going on with the University of Texas program. And I think it's an important quote because it's clear, everyone agrees that Texas did the absolute utmost to comply with law here. Grutter came down in 2003. They began to modify their policies the following year in 2004, and they basically mapped their policies upon the Grutter decision. And so they used a holistic, multi-factor approach. Race is one of many considerations. And so the lower court in Texas granted summary judgment to University of Texas. This means a trial is not necessary, that a decision can be made as a matter of law, and the judge thought that there was no genuine issue of material fact that required a jury determination. So the judge granted summary judgment in favor of University of Texas and said that it would be difficult for University of Texas to construct an admissions policy that more closely resembles the policy approved by the Supreme Court in Grutter, and that as long as Grutter remains good law, UT's current admissions program remains constitutional. Laying aside the top 10% law, that observation is indisputably sound. So you have the lower court as well as the Court of Appeals in Texas, the Fifth Circuit Court of Appeals, two levels of the federal judiciary. The Court of Appeals is the level of review prior to the Supreme Court level. Both finding that University of Texas's program was like hand in glove with the teaching of Grutter on how to design a program to unleash diversity to the maximum extent possible and put as little emphasis on race as possible. So I think that's an important point because it doesn't leave a lot of room for the Supreme Court. Now there is a difference between Grutter and Fisher and Michigan and Texas, and that's this top 10% law that Texas enacted during a time period when the appellate courts in Texas had completely outlawed the use of race as a consideration for admissions within the Fifth Circuit. That's called the Hopwood decision. So in response to that ban, that temporary ban before Grutter and the Supreme Court ruled that you can use race, the Texas legislature approved a new approach to admissions that I think was pretty creative. They said, if you graduate from a Texas high school and you're in the top 10% of your graduating class, it doesn't matter what your SAT scores are, nothing matters, you are admitted. And it doesn't matter what race you are, you're admitted to the University of Texas. So that had the effect of making sure that the University of Texas benefited from getting the best students at every high school in Texas. And that included necessarily high schools from areas that had high concentrations of minority students. So in response to the top 10% law, the idea that if you're in the top 10%, you get into University of Texas, diversity went up as measured by the number of Latino students and the number of African American students. So the top 10% law worked, and it worked to such an extent that the problem of losing diversity after Hopwood went away, and basically the University of Texas was able to get a large degree of diversity as a result of this race-neutral top 10% plan. So that begs this question. They took the top 10% plan, and today that constitutes about 80 to 85% of the students admitted at the University of Texas. But they had a problem, and the problem was that even with the diversity yielded under the top 10% plan, they still had too many classes that had virtually no diversity within them. Remember, the whole point of educational diversity is robust exchange of ideas in the classroom. So Texas allowed many students in of color pursuant to the 10% plan, but they still had all white classrooms in a lot of areas and in a lot of subdisciplines. And so in order to remedy that, they went the extra mile to try to diversify their classrooms in accordance with what the best teaching is from experts in education on the benefits of diversity. And they put in place, in addition to the top 10% plan, a Grutter plan, where they would explicitly consider race as one factor among many in a holistic and individualistic way, in an effort to make every classroom at the University of Texas a place where the benefits of diversity could be attained, where the educational benefits of diversity could be attained. So even an opponent of that program, the Grutter program and the explicit consideration of race, Judge Garza, had to concur in the opinion at the Fifth Circuit level, at the Fifth Circuit Court of Appeals. And the language from his appeal is from his concurring opinion is interesting. He doesn't like Grutter, and he writes extensively on the need to overturn Grutter. But he basically says that, like the majority, the University of Texas complied with then existing law beyond a doubt. And the only way that we can change the outcome in this case is based on overturning the precedent of Grutter. So there's been some discussions about whether or not this was outright racial balancing. I think that's a hard argument to make. And the reason why it's a hard argument to make is if you look at the numbers, the math doesn't add up. So for example, the percentage of Hispanics at University of Texas is less than 2/3 the percentage of Hispanics in Texas. And the percentage of African Americans at UT is half the percentage of Texas's African American population, while Asian American enrollment is more than 5 times the percentage of Texas Asian Americans. So it's not as if Texas, the University of Texas, is trying to impose a backdoor quota system so that way their student population looks much like the population of Texas. That's not the issue here. This is not a situation where you can really argue that outright racial balancing is in play. If it were outright racial balancing, that would come perilously close to a quota system and would probably be unconstitutional, and so says Grutter. But I think these numbers belie that. And I think that Judge Garza's concurrence, he's basically against the whole idea of Grutter. If he could have argued that it was outright racial balancing and it was unconstitutional under Grutter, I think he would have. But instead, he said the way we have to fix this is not by saying it doesn't comply with Grutter. We have to overturn Grutter. So let's talk about another idea, race-neutral alternatives. The idea here is because we don't like racial classifications in America under the 14th Amendment, the law has subjected such classifications to what's called strict scrutiny. And they must be imposed. Any kind of racial classification has to be imposed in a very narrowly tailored way, which means that you only go so far in considering race as is necessary to serve a compelling state interest. So the question here is, did Texas really pursue all race-neutral alternatives? And I think a very good argument can be made that because of the top 10% law, which specifically sought to diversify the University of Texas based upon race and ethnicity, that Texas did in fact try to use race-neutral alternatives to the maximum extent possible, and that as a consequence, it's very hard to say that their approach is not narrowly tailored based on the alternatives open to them. So I think that University of Texas basically did a very good job of doing what was necessary to bring their plan into compliance with the Supreme Court's decision in the Grutter case. So that raises this question. Should Grutter be overturned? Well, it actually raises a lot of questions. Should we ignore business and military experts that diversity helps us to compete more effectively, both in the globalized economy and in terms of military power? Is this a compelling interest to compete more effectively, and is race crucial here? Well, these are difficult questions. I think the first question is that the empirical evidence on the benefits of diversity, both in the military and in the world of business, is overwhelming. It's absolutely overwhelming. It's not beyond any doubt that you can get benefits from diversity. It's not that just taking a lot of diverse people and mixing them together and hoping things work out necessarily get you those benefits. But there is a powerful, powerful theme in the empirical evidence that if you manage diversity appropriately and you bring people together from various backgrounds and various experiences, and you allow those people to voice their ideas freely, that you do achieve better outcomes. Now, that's different from saying that skin color is what matters. What we're really focusing here on is ideas and thoughts and experiences and perspectives. Now, unfortunately, we don't have the ability to determine who has the best diverse. It's not like you can put someone's head in an MRI and get a diversity score, right? You can't take someone's head and ding, 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 diversity score 10, and take another person and get diversity score 7. So what we can do is we can take advantage of our racialized history. We can take advantage of the fact that we still have huge aspects of racial divisions permeating our society, from infant mortality to incarceration rates to college graduation rates. You see huge differences between white America, African Americans, and Latinos. But what that means is that necessarily being of a different race in America gives you a different experience as America. The American experience of a Latino and the American experience of an African American and the American experience of a white American are fundamentally different. You experience America in a different way, and those experiences give rise to different ways of thinking about things, and they give rise to different ways of thinking about different issues and problems that America faces. So if we're going to be effective as a diverse society, I would suggest to you, with respect to these first questions, that we shouldn't ignore the business and military experts that talk about the benefits of diversity, that is a compelling interest. Now, is race crucial here? Do we have to consider race to get the benefits of diversity on a society-wide basis? Well, I think probably yes, but I understand that this question is more difficult to answer than the first two. And the basis for my probably yes is this. Because we have such huge racial divisions, it's easy to determine diverse experiences and perspectives based on race. It lowers the transaction costs of diversifying whatever institution you're trying to diversify, whether it's the military, whether it's big business, or whether it's Kansas State University. It's easier and less expensive to do it if you rely a little bit upon race as one of many factors in a holistic and individualized way. So that's where I'm at on that first bullet point. Second bullet point, should we ignore social science evidence regarding the value of diversity in the classroom and beyond? Is this value compelling? Is it racial diversity that counts? Well, if you look at the social science evidence, they frequently themselves plug into their analysis race-based considerations. So when they measure diversity, they measure it based upon things like different races and different ethnicities. So it's hard to say at this point in our history that we can unlock those benefits that are being found through social science empirical studies without relying on race. Now, it's probably true that a white person raised in a Hispanic community is going to have more diverse perspectives on what it means to be a Latino in the United States today than someone whose parents are from Latin America or whose grandparents are from Latin America who lives in an upper class white suburb. So I'm not saying that this diversity is bound up with traditional markers of race, the way that you look, right? It's all about cognition. And even white candidates can add diversity in a way that's important. I'm not discounting the ability of white America to contribute to a robust exchange of ideas in any way, shape, or form. But I do think that if you want to get differences in America today, relying on race does assure with a high degree of reliability that you will bring different perspectives and experiences to the table. So I think it's very important to keep that in mind. Should we ignore 35 years of precedent? Remember, Bakke approved the use of race as one consideration to unlock diversity in 1978. There is something in law called the doctrine of stare decisis, and stare decisis is the foundation upon which our common law system is built. The idea of stare decisis is that something that has already been decided should guide decisions in the future. It gives stability to law. It makes sure that judges are subject to the rule of law when they decide issues, that they're actually restrained. Judges, after all, are not elected officials. They are appointed by elected officials. So when you impose a restraint of stare decisis, it means that the judiciary says what the law is, but the judiciary doesn't make the law. They follow the law. And I think that it's true that if you're a justice of the Supreme Court and you're talking about what the United States Constitution means, that stare decisis may not be as compelling as in other areas. But here we're talking about 35 years of practice in America. We're talking about the culmination of a massive amount of litigation, huge amount of investment of resources. Grutter gave us an answer on how to manage diversity in a way that minimizes the use of race and maximizes the benefits of diversity. I don't know if we can improve on that at this point in time. Maybe in the future we can, but I still think that there's something to this idea of stare decisis. The Supreme Court of the United States ought to be guided by the fact that a number of Supreme Court justices over history have looked at this issue. Justice Powell was appointed by the Nixon administration. Justice O'Connor was a conservative appointment too, Ronald Reagan. And so consequently, it seems to me that there is good reason to defer to stare decisis at this point. You can always readdress affirmative action based upon race and college admissions 5 or 10 years down the road, as Justice O'Connor recommended. But we're not 25 years down the road. We're only about 4 or 5 years down the road. And so I think that at this point, stare decisis should fit into your analysis of whether or not you want judicial activism, where judges just basically reinvent the wheel on every issue that they find politically or ideologically important, or whether or not you want judges who are constrained within our common law system to only overturn precedent under exceptional circumstances. Should we ignore the economic costs of the continued sway of race in America? These costs amount to trillions, as nearly 40% of our children of color live in poverty today. Is affirmative action the only means available out there? Well, we live in a society that is greatly burdened by very high degrees of economic inequality. We live in a society that is burdened by an extent of economic inequality that is unprecedented in our history. Never before has so much wealth been in so few hands as today in America. And that is not costless. America was at its most successful when there was less economic concentration. Every extent of economic concentration means that there's another class of Americans who have far fewer resources than has historically been the case. And this great divergence in control of resources leads to bad outcomes in terms of law. It leads to bad outcomes in terms of economics because you lose your middle class. And the idea that we in America, the United States of America, would stand by idly while 25% of our children live in poverty, which is the case today, is to me unfathomable. And it gets worse when you think about it in a racial way. So 31% of Latino American children live in poverty today. 39% of African American children live in poverty today. What are we doing about this? Is this morally acceptable? Does this make sense economically? Our level of childhood poverty rivals that of Mexico, and is one of the worst among all developed nations in the world. Poverty levels go down all the way to 4%. Childhood poverty in Northern European countries goes down to 4%. So what is there to alleviate this race-based childhood poverty nightmare other than affirmative action? I don't see any initiatives anywhere that suggest we as a country are willing to take on this issue of very, very high inequality, take on this very morally disturbing issue of childhood poverty other than affirmative action. I'm all ears if you all want to talk about ideas besides affirmative action, but right now, race-based affirmative action is the only game in town on this issue. So there are alternatives. One alternative to think about, maybe we could call this Plan B. One alternative to think about is rather than use race as a factor in college admissions, use socioeconomic status. The statistics you see on the PowerPoint slide show that when it comes to percentage of children in poverty, there's a huge racial division here. So what does this mean? It means that if you as a university are looking at childhood poverty and you conclude, which I think would be the only way you could conclude, that children in poverty are the most disempowered people in our society, I don't think there's any doubt about that, then what you're basically saying is that the greatest potential for our human resource development as a nation is in this community right here. These are the people who have been the most oppressed, the most disempowered, and therefore, by definition, they have the highest potential for advancement if we give them the resources they need for advancement, right? So as a university, it would make sense to me that you might conclude that if we want very successful graduates, If we want to do our job as a university in the state that we reside in, one of the things we should think about is helping the people who are the most disadvantaged, because that's where the greatest potential for economic development resides. And just as a side note, right? I'm not being race conscious here. Just as a side note, you might note that if you use poverty as the basis for your admissions rather than race, you still end up 32% of Hispanic kids would qualify under such a program. 38% of black kids would qualify under such a program. So you would necessarily, in our racially divided society, end up with a high degree of racial diversity, even though you're using a race-neutral factor. That is, whether or not someone grew up in poverty as a potential for bringing them into your university. So that would be an alternative that would still yield a high degree of racial diversity. Note too that you could also use low income. The difference here, the blue bars are $22,000 a year for a family of 4. Those are the blue bars. That's defined as poverty. The orange bars are $44,000 a year for a family of 4. So if you use the orange bars, 63% of Hispanic kids live in low-income houses, and only 31% of white kids live in low-income houses. So if you use low income as your factor, you end up with twice as many Hispanics and blacks as you do whites in your applicant pool. But here's the question. I mean, this is attractive to me. I believe that if we do this, we're focusing on the people in the greatest need. I think if we do this, we're focusing on the people with the greatest suppressed potential, because they're the most disempowered. But the problem is, I don't see anyone in America talking about doing anything for these people. So besides affirmative action, is this really realistic that universities are going to start pursuing this as their plan B? It's out there, it exists, it's race neutral, it would almost certainly be constitutional, but I don't know if politically there's any firepower behind it. We do know that affirmative action is real, it's viable, it's here, it's now. So what about some other affirmative action programs? Well, you know, I can't help but reflect on the fact that the number of slots up in the air pursuant to the University of Texas affirmative action program, if you do the math and you run the numbers carefully, is about 3% of their incoming class. So all of this litigation we've been talking about is about 3% of their incoming class. But up to 60% of our elite universities reserve spots for the rich and powerful. So I'm talking about affirmative action for legacy admits, affirmative action for wealthy donors, affirmative action for those playing obscure sports like crew, affirmative action for celebrity families. A Wall Street Journal analysis of this done by Daniel Golden, who has a great book on this called The Price of Admission, found that when it comes to who's benefiting from affirmative action the most, it's absolutely the richest, most powerful parts of our society, and not the most disadvantaged parts of our society, the African American and Latino kids who are growing up in poverty. Unfortunately, because of the structure of the Equal Protection Clause, strict scrutiny is only reserved for racial preferences. So all of that affirmative action we just talked about, that stands under the 14th Amendment jurisprudence as it stands today. Let me suggest a couple of things. There are some very complicated issues on the table here. I'm hoping that some of you came to this talk today because you wanted to learn more. And if you're learning, that means you're changing your mind, by definition. When you're learning, you're changing your mind. So I want you all to think harder about these issues that we've raised today. I'm sorry I don't have more time, but there are some websites here, and I'll be happy to email this slideshow to anyone who gives me their email address. The American Bar Association has every single brief in PDF format on its website. The Scottish blog has a symposium that you can access on their website. The United States Supreme Court will have the full audio of the oral argument the week after October 12th on its website. And so I urge you to think harder about these issues, to think more carefully about these issues, and to try to learn as much as possible, and that you view today as a beginning, not an end point. Then finally, I wrote a book on this. And the name of the book is Lawless Capitalism. It's not out yet, but you can pre-order it on Amazon.com at the address you can't read because the print is too small. And basically the theme of the book is this: we have allowed our society to be subverted by excessive economic concentrations of wealth. As more and more money has been held by fewer and fewer hands, they have used that money to ever more subvert law and regulation in their favor, so they make money while the rest of us lose. I would suggest to you that affirmative action is such a case, that we have a situation in America where there isn't enough educational opportunity in our country, and we ought to at least try to equal out access to educational opportunity and not continue to be haunted by our racist history.
Very much, Professor Ramirez. Well, I'll now turn the floor over to Dr. Herrera. Is she here somewhere? Yeah. And she will give you the next step in our program, and the goodies are out there somewhere.
Well, first, thank you, Professor Ramirez. That was outstanding. A round of applause. Yeah. I think Professor Ramirez has given us what I like to think of food for the soul. And the reason I think of it as food for the soul is that oftentimes when we think about issues, challenges, cases that are of this type, we respond from the heart, from our primary socialization and the experiences that we've had. But he ended by saying we need to think and we need to learn. And this is a beginning point for that. It's beginning to hold conversations that are rich and not be afraid to say how it is that we feel in our heart and how it is that our thinking is beginning to change as we learn more about the implications that this has for the future of this great nation. So what we're going to do next is, how many of you are sitting next to a friend or someone you know from class? Raise your hand. Okay, and don't be afraid. It's all right if you came with your friend. You know, I might not want to say I know them either, but what we're going to do is I'm an elementary teacher, so this comes from my background. We're going to look for our soulmate. Our soulmate, you know, not this soul, but our footmate. We're going to look for someone who is not our friend, who's not sitting at our table, who is wearing shoes of the same type that we are. You don't have to be scientific about this. It just has to be maybe you both have shoelaces, or maybe they're the same color. And once you find that soulmate that you're going to have a rich conversation with for the next few minutes, sit down. But I want to see everyone get up, find someone different, and then just find a table to sit down. So. I'll have it. And please, before you sit down, go over and get your lemonade and your cookies. And the debate goes on. The conversations are very rich, very dynamic, and very safe. I wondered if when you were in your groups you would feel safe to take a position. So it's wonderful that you are. What I'd like for you to do now is to actually take a vote at your table. You know, who are the yes? Who are the no? No, you have a few more minutes. It would be great if you have a chance. It would be great if you had a chance. When you vote yes, say yes because, very short. The next person, no because. Still thinking, I pass. You have the right to pass. But go ahead now and take a vote. You have about another 5 minutes. And then we're going to pick up the cards and give you the count, and maybe have some of you share out if you feel like you'd like to. Okay, we need the drum roll now because we've tallied the yeses and the nos and read some of the comments that you made. We have 78 yes. Oh, one more. We have 79 yes. One more. And we have 43 no. Okay, and some of the comments is, instead of race, shouldn't we be thinking about socioeconomic status policies? And some others is, no, it should be based totally on merit, should be based on the ACT and other test scores. And the other is, I'd like to sit with that group on the test score thing, but I won't bring my personal thoughts into this, okay? Yes, minorities don't have equal opportunity to need a chance to prove their achievement, so they don't have equal opportunity to have access, is the way that I'm reading that. And no, if you want to succeed, go to college, work hard, and you will be accepted regardless of whatever scores or background you have. No, because we believe it should be based on economic status. No, laws based on race, background, not race. All people have the same rights, which should be based on capacity to learn and skills. And I'm not going to read all of them, but that gives you a gist. And I find it very interesting. It'd be something we could talk about, that people who had the no's are the ones that wrote the basis for their no to support why it is that they thought the way that they did. But you did have your basis for your yes, but you wrote it in the front. I was looking out. How about standing up? Because that's where we're going to go now. Anyone who would like to share out some thoughts, we're going to whip around the room. We have to have at least 3 people just share out. What do you take away from this type of activity? Yes? Well, you have to use the microphone. So now that, do we have one that right here. So, Myra, I do want you, because you wrote words, but what you were saying articulates some thoughts really, really well. So, okay, can you want to come up here and read it? Now I have to write. Here it is. There you go.
One of the first reasons our table decided yes was because there needs to be some type of reparation for over 200 years, 300 years of mistreatment. And basically what this means is, you can say, oh, I didn't have slaves, I didn't treat anyone bad, but the fact of the matter is you inherited your privilege from those people who enacted those types of things. So you have to take some accountability for that. The second one was economic justice and longevity. And this is because the minority is becoming the majority. So if we're not provided with these types of opportunities to help us, then who do you expect to be paying for your Social Security when you're 65? We're running out of white people to run the country. So pretty much, that was kind of blatant, but pretty much so. You have this massive group of people who aren't prepared to be in these positions of power, to run the country, to run big businesses, but then you expect to be comfortable when you get old. So that kind of just doesn't add up. And we're not provided with the opportunities or the support from our country to even be able to stand up in these positions. And then the last one is to avoid a revolution. We have an economist at our table, and he was discussing the effects of having an elite and then a lower class, and we were kind of all discussing this, and what happens when the middle disappears. Then you have this large society within the society that creates their own laws and their own rules, and they start governing themselves, even if this is against, like law. It's called like maybe criminal acts are happening, but they're doing whatever they need to do to survive. And so eventually this revolution will happen, and then America as a country will just collapse in general. So this is why we say yes in 3 basic points. Thank you.
Do we have someone else who would like to come and share? And you don't have to come up here. You can also come to these 2 microphones. I heard lots of great thoughts. So, and you may just be tired. How many of you are tired and ready to go have a cup of coffee and do homework?
Well,
or something. So,
in that case, it's time to say goodnight. But let me say one thing. What you've been talking about, the yeses and the nos and the comments, reflect something that's very common and widespread in our beliefs about this question of racial justice and racial access. The person who said admission should be based on SAT scores, this is a very strong and legitimate criterion for admission, because the purpose of universities is to train people who will do a high quality of work, who will be understanding and wise. And we want to be honored for our achievement and get into school and have it recognized that we've achieved something that showed that we deserve to be there. And you know that because all of you have gotten awards in your life and you've seen other people get awards. You can't take that out of our culture. So I think that this disagreement is inevitable because all of us believe something of what that particular person said. Then the other thing is the idea of compensation. The compensation argument, you brought that up too, and the compensation argument is this, is that we have a society in which some people are not able to compete as well for admission because they haven't been given the tools, and they haven't been given the tools because of the history of the mistreatment of people of their color or race. The question there, though, is do we have collective responsibility for that today because others have done that before us? Or should we use the resources we have to equalize this mismatch, this lack of skills that these people need to have? And on that issue, that's an educational issue. And we know that we're trying to do that. So I think that's also important. And I think that person who wrote that, and I think we heard that from you, was quite accurate. Another is this idea of utilitarianism, really, that the greater good will occur for all of us if we don't keep one group of people educationally, culturally, and financially suppressed. Because if we do, there are going to be bad consequences. And that's a consequential argument that's also common. But finally, the diversity issue that drove the Fisher decision and all those that came before is that diversity in education as a way of creating a better society by bringing different viewpoints together, this was chosen as the goal of the University of Texas. Do schools have the right to determine their own criteria and then say to people, you will be admitted or not admitted if you fit those criteria? And people will say, well, I worked hard, I should have beat out the person that the school wanted because they were a person of color, they had lower scores than I did, this isn't fair. But in a sense, it's very fair if the mission of the school is to give people who are different the opportunity to educate themselves and others through developing the critical mass. So you have really discussed here all these important issues. And what's the best part about all this is to have watched this, to see the most diverse group I think I've ever seen in Kansas is sitting right here. To see the leaders of the group not talking, to see the students and the members of the public talking and not stopping. This is what education should be. This is why you came to college. And I just want to thank you because To me, it was a great program. I loved Steve's talk, but then I saw this, and I have to say that this won my heart. So thank you very much, and we'll see you at another Dorothy Thompson function.